Okay, we're back again. I'm Dwayne.
I'm JC.
And we're going to talk just for a moment or two about what you can expect to happen in a bankruptcy once you file it. Now, what's already over is you've looked at your situation and determined whether or not you even need to file for bankruptcy. You've decided whether you're going to file it, if you do need a bankruptcy, whether you're going to file a Chapter 7 or a Chapter 13. Okay. Then you've assisted our offices in preparing your bankruptcy paperwork.
Yep.
Okay, you do most of the work, we get all the glory. Okay, there's a lot of information gathering that goes on.
Just like my house. My wife does all the work, I take all the credit.
And the purpose of you doing so much work is because we really want your case to be accurate when we file it with the court.
And you're going to be attesting under oath, swearing under oath that it is.
And our job is to make sure that you get as good of a relief from bankruptcy as possible. And so we're going to be asking lots of questions to determine whether or not your paperwork is truly complete and accurate. So we're now at the point that it's time to file your bankruptcy. We're either going to file a Chapter 7 or we're going to file a Chapter 13, but we're filing bankruptcy. What does it mean? So what we do is we don't take it down to the courthouse anymore. We used to walk it down and put a stack of paperwork in front of the clerk of the court.
Now it's a long series, I believe, of electrons that transmit in various methods and over various media to go from our office through wires, satellites,
Enthralling, Dr. Cox. But what he means is we upload it. We upload your case, and once it's uploaded, you've got a bankruptcy case number assigned to you. But the best thing, well, a judge is assigned to you, to your case, and a bankruptcy trustee is assigned to your bankruptcy. And so the moment we file for bankruptcy, the bankruptcy judge issues
an order.
An automatic stay.
A temporary relief.
That tells all your creditors you have to back off. They have to back off. They can't continue to harass, call, sue, threaten to sue.
Continue a lawsuit that's already in progress.
Garnish, repossess, foreclose.
Yeah.
Is that all you can come up with? One?
I'm
doing all the heavy lifting here.
Yeah, like I said, I get people to do all the work and I take all the glory.
All this stuff has to stop. Now, the things that aren't going to stop, collection
of domestic support.
Child support, spousal maintenance.
There you go.
Continuation of criminal proceedings, they get to continue.
Dang it.
That doesn't happen very often. Our clients are well above.
They're wonderful people.
Okay.
And not just saying that sarcastically. They are wonderful people.
Okay. So most everything has to stop in its tracks. It's like JC mentions, it's a temporary injunction. It's only temporary because a creditor could come in and ask the court to lift the automatic stay if they have a good reason, meaning you're not making payments on a car or a house,
exactly.
Or you're behind on a car or a house before we file and continue that default.
And if they can show that, in a nutshell, it wouldn't be fair to them and the assets that they're relying on, right, that are collateral for their debts, that they, for the debt that you have taken with them, if it wouldn't be fair for them to just sit back and let you continue not paying, then they can get permission from the bankruptcy court to do the things that they could have done before you filed bankruptcy. But again, they have to go through that process. They can't just come and try and take the property from you or continue to try and collect.
He's correct. Not really that interesting, but he's correct. Okay, so we filed the bankruptcy. The automatic stay goes into place. What's going to come up next?
Next, we are going to have a hearing.
Okay.
So every person that files bankruptcy has a hearing. It's called the 341 meeting or the 341 hearing or the meeting of creditors. Mm-hmm. There's never any creditors there.
That's rarely does a creditor ever come to attend your meeting of creditors.
So the meeting of creditors, you go, we would go with you if you hired us, which you should have. So we would be there with you. It's with the trustee. It's not with the judge. And it's the opportunity for the trustee, after they have reviewed the paperwork that was filed in your case and additional paperwork the trustee will ask for, after the trustees reviewed all that, to ask you questions about your eligibility to file, any previous bankruptcy filings, assets that you may own, whether you listed all your debts, and all this is done under oath, penalty of perjury, which is why, as Dwayne said, it's absolutely critical for you to know your case, which is why we have you put all that information together in the first place, so you can answer those questions honestly and completely and have confidence in your answers and know that you're not getting yourself in trouble.
The bankruptcy trustee that's at the hearing there has the responsibility to gather from you any assets that are not exempt. We talked about exemptions before. If there's anything that you own that's non-exempt, the trustee is going to gather it in, sell it, turn it into cash, liquidate it, which is why Chapter 7 is called a liquidation
go.
proceeding, and distribute those proceeds out to your creditors. That's what's going on in a Chapter 7 bankruptcy. And that's why they hold this hearing, is so they can initiate the process to determine whether or not the information you put on your schedules and your petitions were accurate.
Now, this could sound really scary. Typically, a 341 hearing is going to last 5 minutes or less.
Yes.
Most of the time, unless you have kind of an unusual situation and the trustee really needs to ask a lot of questions. They're very routine. Most of the questions get asked to every single person that files, and when you're sitting there and there's 5 other people scheduled for the same half-hour block that you're there, you get to hear all these questions. So you don't need to get really stressed and upset about it. We do a lot of work up front to make sure that if there are things the trustee is going to be asking about, we've already talked about them, and it's not going to be a surprise there.
The meeting of creditors, a lot of times clients will ask, will there be anybody else there at that hearing? The fact of the matter is these hearings go by so quickly that the court will schedule maybe 6 or 7 hearings for the same half-hour period of time. So yes, there'll be other people there at the hearing, but they're there for their own case, or it's their attorney that's there. Very rarely will there ever be a creditor there. I remember not having explained this to my client at one point, and we walked into the hearing room and it's full of people and they thought the inquisition was about to begin. That's not the case. Don't lose any sleep over that hearing. It's not a big deal.
No. Usually the only creditors that are there are creditors that aren't used to being creditors, and they don't know that
Why they were
that
given
they don't
notice from
need
the
to be
court.
there. They can handle everything,
Yeah.
again, with those electrons.
Now, you've attended the meeting of creditors. What's going to happen after that? In a Chapter 7 bankruptcy, creditors have 60 days from that date to file a complaint for non-dischargeability. It's a lawsuit where they come in and say, Your Honor, we think the credit card that JC owes to Capital One, us, should survive bankruptcy because JC misled us on his credit application and he used a lot of credit shortly before filing for bankruptcy, and he's just a bad person, is
Well,
what they will allege.
That's all true.
No, the stuff they say is rarely ever true. But sometimes they want to just try to get you to agree to some sort of settlement. The reality is fewer than 2% of the cases that I filed over the years have had a complaint for non-dischargeability. But they've got 2 months to raise that issue. If they don't raise it within those 2 months, then they're barred.
And they're done.
Okay, too little, too late. Now, there's an exception. If you don't list them when we originally filed the bankruptcy, they get a little extra time if we list them later on
Bad
to
idea.
file the complaint for non-dischargeability.
List all your debts.
Oh, just look
think
at
we've
the
talked about
previous
that.
video. That's right. Now, after the 60 days have expired, then the clerk of the court, or really the computer, is going to issue a discharge if you have submitted your post-filing
Class.
personal financial management class.
There you go.
Thank you. Remember, before you file bankruptcy, you have to do a pre-bankruptcy, it's a credit counseling.
Credit counseling, that's
class
the
that
one.
you get a certificate on. And after you file, then you need to do a post-filing personal financial management class. That needs to be entered. If it's not entered, you will not receive a discharge in your case. But once you do receive a discharge, it's an 8.5 by 11 sheet of paper that says you're discharged from all your dischargeable debts. There might be something that survived bankruptcy.
Could be.
Be sure to hang on to your paperwork, both your petition that was filed, your schedules, your master mailing list. Hang on to the notice of 341 hearing. Hang on to the discharge order and keep it all in one place. So if a creditor tries to collect from you in the future,
You pull that out. You tell them, no. You send them a copy of your discharge. You were discharged. If they keep bugging you and you hired us like you were supposed to, then you just give us a call and we make sure they know that they are now in violation of a federal court order ordering them to leave you alone.
which was the discharge order, which is now a permanent injunction, not like the temporary injunction that we mentioned before. This is a permanent injunction that tells them they are forever barred from trying to collect this debt. And if they do, they're in violation of a federal court order.
Which is never a good thing.